the general contracts, general provisions, or we have already discussed. So now we are just moving on to special contracts. Yes. Actually, there are 5 special contracts like indemnity, contract of guarantee, bailment, then pledge, and contract of agency. So these are the 5 special contracts we'll be discussing. So today we'll be just discussing about 2 special contracts, that is indemnity and guarantee. So 5 special contracts are there, that is contract of indemnity, contract of guarantee, then contract of bailment, then pledge, and then a contract of agency. Sections 124 to 147. So that is dealing with 2 special contracts like contract of indemnity and contract of guarantee. 124 and section 125. Only 2 sections are there with respect to contract of indemnity. And contract of guarantee is dealing with section 127 to 147. So these are all very small sections and we'll cover it. So 124 and 125 is a contract of guarantee. 126 to 147, 124 and 125 is a contract of indemnity, and 126 to 147. So that is dealing with contract of guarantee. So first we'll discuss about what is contract of indemnity. The word indemnity means security or protection against loss. So that is the word meaning of indemnity. So indemnity means it is a security or protection against loss. So what does this contract of indemnity means? It is a contract by which one party promises to save the other from the loss. So one person is promising to save the other person from some sort of loss. And how that loss is caused? That loss is caused either by the conduct of the promisor himself or by the conduct of any other person. So this is contract of indemnity. Here, one person is known as a promisor, and is also known as indemnifier. And he promises the other person. So here, promisee or indemnified or indemnity holder. So he is promising the other person to save him from some sort of loss. And how this loss is being sustained to the party? Either by the conduct of the promisor himself or by the conduct of some other person. Suppose Sophia is having some legal proceeding with Sarah, or let it be. So in that particular instance, if I am the promiser, I used to, I'll just promise the Sophia that I'll just help you, or I'm giving a promise that if there is any loss caused by the contact of myself or by any other person, I shall discharge, or I shall give you a promise. So that sort of promise is what we call by this contract of indemnity. You're saving or you're protecting from any sort of loss. And that loss, so here, if any loss or if any injuries are sustained as a result of accident or insurance, they are not at all coming within the ambit of this contract of indemnity. So they are not special contracts, but they are not coming within the purview of this contract of indemnity. So in order to conculcate or to bring into the contract of indemnity, there should be two parties. One is a promiser, whom we shall also call by name indemnifier. And the other person is indemnified or indemnity holder or promisee. So only two parties are there in this contract of indemnity. And whatever, so at what time this particular contract comes into force? When a loss is sustained to the indemnity holder or promisee or indemnified, then only this particular contract of indemnity comes into force. If a loss is sustained to the party, to which party? Promisee or the indemnified, or you call it as him as an indemnity holder. When there is a loss, only this contract comes into existence. And whatever the formalities of the contract where we have discussed in our earlier classes, there should be intention to create legal obligation. There should be free consent of the parties, lawful consideration, lawful object, competency of the parties, and not declared void by. So these general principles are also has to be satisfied so as to bring the contract into existence. So all the essentials of the contract, all the general principles underlying the contract, all will come into force in special contracts too. So two parties, there is an intention to create legal obligation. There should be consensus ad idem, lawful consideration, lawful object, free consent, competency of the parties, and of course, it should not be declared void by any law for the time being in force. Now, we have to discuss what are the rights of these indemnity holders when sued. So, the indemnity holder, that is the promisee, or you call him as an indemnified, he can recover the compensation, he can recover the pay, the cost. So these are the rights of the indemnity holder or promisee or indemnified. And again, if there is an absolute liability as per the terms of the contract, of course, he is having the right to sue for specific performance. So they can also have a right to sue for specific performance of the contract if there is an absolute liability as per the terms of the agreement. So that's all with regard to contract of indemnity. So very simple. The two parties are involved, a promiser whom we also call by indemnifier, and the other person is a promisee, is the indemnified or indemnity holder. So what is the promise? He will save the other from the loss. And the loss should be sustained as a result of what? There should be a loss sustained as a result of this conduct of whom? The promiser himself. Or it can also be the conduct of some other person. Only under these instances, when a loss is sustained, only this particular contract of indemnity comes into force. And this indemnity holder or the promisee is having all the rights to recover the damages or recover the pay or some, and also even to sue for specific purpose of the contract if there is an absolute liability. Now we'll just move on to section 126. So section 126 to 147 was dealing with contract of guarantee. So contract of guarantee means it's a contract to perform the promise and discharge the liability of a third person in case of his default. So it is actually a contract to perform the promise and also to discharge the liability of a third person in case of his default. So here there are three persons involved in the contract of guarantee. So it is known as a tripartite contract. So that contract is entered there are three persons are involved in this contract: one surety, one creditor, one principal debtor. So it is also known by the term, it's a tripartite contract. Three persons are involved. So how is this contract works? Here, the surety is promising that if there is a default from the principal debtor, he will discharge the liability, and this promise is given to creditor. So surety is giving a promise to the creditor that if the principal debtor is not paying the amount, I shall pay. So that is the contract. So there is always three agreements, so three contracts are there. One is between the principal debtor and creditor. Another is principal debtor and surety. And the third is creditor and surety. So there are three contracts, three agreements are entered. One is between the principal debtor and creditor. Another is between the principal debtor and surety. Another is a creditor and surety. So that is why it's called a tripartite contract. So when is the role of the surety comes into play? Only when there is a default from the principal debtor. So when he's not paying the amount, or when there is what you call a violation, or there is an infringement, or when there is a breach of an agreement, when there is a default from the part of the principal debtor, then surety comes into play. So this is a contract whereby you could say that the surety is giving a promise to the creditor that if there is a default from third party, the third party is the principal debtor, I shall discharge the liability. So that promise is given to creditor. And here the main question is, what is the consideration? What is the consideration? So all these general principles or all the conditions for a valid contract, it has to be here too. You have to follow that too in this contract of guarantee. And the consideration is nothing but any promise made for the benefit of the principal debtor. So whatever promise is given by the surety for the benefit of the principal debtor, that itself is a consideration. So what promise is given for the benefit of the principal debtor, then that itself is the consideration. So here, surety promises that he will discharge the liability of the principal debtor, and the promise is given to the creditor. And that promise itself, for the benefit of this principal debtor, it is the consideration. Now, how we can just state, oh, what are the liabilities of a surety? So he is giving a promise, and how far he is liable? So his liability is always coextensive with that of the principal debtor. How far this principal debtor is liable, he is liable to that extent. So his liability is always coexistence to that of the principal debtor. How much of what all causes this principal debtor is liable, then the surety is also liable to that extent. There are different kinds of guarantees, like prospective guarantees, retrospective guarantee, specific guarantee, continuing guarantee. Then for entire debt guarantees there, for partial debt guarantees there. So these are the different kinds of guarantee, like prospective and retrospective, that is guarantee or is given to a future transaction, then it's a prospect. When a guarantee is given for a past contract or past transaction, then you could say that it is having a retrospective gap.